For the week of November 16th, this is what's coming up on CT Examiner Weekly.
I'm Editor-in-Chief Greg Stroud with a look at the big story for CT Examiner involving a 2018 death in a Connecticut prison and the public's right to know of exactly what happened.
And I'm reporter LeMaster, who's been covering this case, and I'll bring you updates on it, including the latest on the release of the video of J. Allen Jones.
And I'm columnist Chandra Bozelko with a story about a 30-year-old prison initiative called the Inmate Legal Assistance Program and how it may be doing more harm than good for Connecticut inmates seeking to access the courts.
All that and more in this week's edition of CT Examiner Weekly. I'm your host, Brian Scott Smith. Welcome to you all. This week is all about the criminal justice system here in the state and how it does and doesn't always work the way it should. CT Examiner took the unusual step earlier this year to team up with a lawyer to intervene in the case of J. Allen Jones, a young man who was murdered in 2018 while incarcerated at Garner Correctional Institution in Newtown here in Connecticut. Greg Stroud, Editor-in-Chief of CT Examiner, and LeMaster are with us today, as they have both worked extensively on this case and the story. So, Greg, how did CT Examiner come to hear about the J. Allen Jones case to begin with?
Well, the J. Allen Jones, when an inmate dies in prison, often the news is out there, but exactly what happens and how it happened, that's a little bit more complicated. In this case, I'd actually caution us. The word murder, I feel, maybe a little bit overstating or misstating the technical. It's a homicide. It is a case where a man has been ruled he was killed by other people, in this case, 9 staff members in the prison. But no one has been charged. And no one has seen the video footage. So this was a death in 2018, and that video footage has still been suppressed by the state. And that's what we've been trying to get for these last months.
So how exactly did the case come to light to you? Because like we said, this is a 2018 homicide case.
So in this case, we were looking for an appropriate time to intervene. When could we take our limited resources with the press and make a difference? And part of that is we needed a lawyer, and we paired up with a good one, civil rights attorney Alex Talbus. But the other is we came right after a failed attempt by ACLU CT to represent the public's interest in this case. And in this instance, we thought a newspaper would do a better job, and we were concerned that perhaps a settlement in this case with the family might keep that video forever secret from the public. And so in this case, we weren't advocating for the staff or for the family, but for the public's right to know.
Is it unusual for sort of like a media outlet to step in and intervene in something like this? Because you don't hear a lot of that.
You know, you see it in a case if it's the New York Times or the Washington Post or a bigger outlet. It is somewhat unusual in Connecticut, certainly unusual recently. I was actually surprised in this case, given the immense public interest. I mean, we think that this is a case that's every bit as big as the big cases that spurred Black Lives Matter. So, and this one's coming up, and this video will be out.
Let's bring in LeMaster, who also is with us today and has worked extensively on this particular story, as I say, with Greg and other members of the CT Examiner team. Ali, talk to us about your involvement in this case, because this is a big one.
Right. Yeah. So I was tasked to kind of follow the motion to intervene as well as the ongoing court case. So we intervened right before there was a hearing on the video of J. Allen Jones, which depicts his death. And, you know, the subsequent hearing that happened after that was a big deal because you had members of the public, you had Alex Talbus on behalf of Connecticut Examiner, you had Corrections Ombudsman DeVaughn Ward talking to the court and saying, hey, we believe this needs to be public.
So in this case, I think context really matters. And we have a remarkably similar case in 2019 where another inmate who had also been diagnosed with sort of mental health issues was killed in a Connecticut prison. And there is video of that death. And that video has never been released and likely never will be released to the public. And so that was something, certainly this was a time where a settlement could be reached, where the public dollars could be used to essentially satisfy the family's claims and suppress the video. And we just didn't want that to happen.
But I will say that attorneys on behalf of Jones's estate have pushed for this video and have really, really, advocated having these, marathon hearings over this exhibit, the video of J. Allen Jones, I mean. And it's immense public interest. And, the judge ruled ultimately that the video should come out, that the Department of Corrections security risks that they believe were posed in the video coming out didn't overrule the public's right to know.
The Attorney General also got involved in this as well, didn't he, Greg? Tell us about that.
So, it's a difficult position you're in as the Attorney General. You're representing the state's interest. And in this case, as interpreted by the Attorney General, the state's interests are pretty maximal in protecting the staff members, to protect, I think, the Department of Correction from embarrassment and to suppress this video. So for me, for a potential, when I look at William Tong, our Attorney General, he's one step away from the governorship, one step away from being a senator. He has a very progressive record, at least on speaking of these issues, but predominantly outside of Connecticut. So this is a chance to see how a powerful progressive politician in Connecticut deals with a case that's every bit as explosive as what we saw in Minnesota 6 years ago or in Missouri 8 years ago. And so the proof is in the pudding.
Let's also talk about, and he was mentioned by Ali a little while ago, the Ombudsman, the Corrections Ombudsman DeVaughn Ward. That's a relatively newly reinstated office here. We used to have it years ago, and then it disappeared. It's been only recently reinstated. Talk to us a little bit about his involvement, because we're going to listen to a little bit of audio from him in a moment of a much longer interview that we did with him. But talk to us about DeVaughn Ward.
So the position of a corrections ombuds was eliminated with the financial crisis in 2008, 2009. And the legislature reintroduced it a few years ago, but it was quite a contentious issue of who exactly would take that position. DeVaughn Ward came in kind of at the last, after the fighting was over. And he's taken a pretty aggressive stance, a very public stance at least, in terms of getting the agency funded, asserting its right to a subpoena and to appear at the prisons without warning or notice. So in this case, DeVaughn Ward is, while he's working for the state, he's tasked with representing the inmates and their interest in this, and making sure that they get their say, if you will.
Which is something that a lot of people probably wouldn't realize is actually available. I mean, it's not in every state either. And like we said, only until fairly recently did the ombudsman come back into fruition here in Connecticut as well. I think there's no part of government that's harder to cover as a journalist, I think, than Department of Correction. There are no sort of witnesses that have a harder time being believed in the courts or in the court of public opinion. And so DeVaughn Ward for us is helping us get this information so that, there's a well-established right that the public should understand and know the conduct of public employees. And in this case, these are Department of Correction employees employed by the public. And so DeVaughn Ward is helping us see exactly what they're doing. Chandra, sorry, yes.
I just wanted to know, Ward actually has an extensive background in litigating conditions cases, meaning conditions of confinement. So he's represented incarcerated people when they've had problems as mundane as not getting a certain diet or being beaten up. So he was actually much more aware of what could happen inside these facilities because he's, one, been allowed in a couple of times, but now also represented them and secured some settlements and some money for several of his clients. So this is a person who really knew what was going on inside DOC.
So in this case, DeVaughn Ward, one of his more significant wins was actually to secure medication and treatment for inmates that have hepatitis C. And in that case, hepatitis C can be a death sentence. But there's expensive treatment that people outside of prison get. And he actually secured the right for prisoners to get tested and treated.
So we've spoken his name a lot. I had an interview with him a few weeks back, and we spoke on many issues. One of the issues that I did ask Ward specifically about was the J. Allen Jones case, and this is what he had to say. We'll take a listen. I want to talk to you about a specific case. It involves a 2018 death of an inmate by the name of J. Allen Jones at the Ghana Correctional Institution. The Department of Corrections and the Attorney General denying requests to release footage of the tragic circumstances around this situation. How much are you involved in that, and what concerns do you have about that?
I testified at the hearing to have the video released publicly. I've spoken to the governor's office about my position regarding the video and that it should be released. The Ombudsman's office was reconstituted in statute in 2022, so almost 4 years after the death of J. Allen. It's not something necessarily I feel compelled to go back and examine very closely. Obviously, it's a case that's in litigation right now. I've tried to bring as much awareness as I could to the case. I recently wrote an op-ed being critical of the Attorney General's office enabling the Department of Corrections position in terms of not releasing the video at all. And as I mentioned before, I testified in favor of the release of the video at the last court hearing that was held on the issue. Since then, we've seen some progress and some movement by the department. It went from a position of, no, we won't release the video at all, to, okay, we can release portions of the video in a closed and controlled setting. And so that movement on that position, to me, represent that they're certainly hearing the public outcry. They're certainly hearing interested parties' statements saying that the release of the video is important for transparency and for healing and for trust to be restored in the correction and criminal justice process. That's kind of where I am with the case. Having looked at it too, it's just such an unfortunate incident. It didn't really come on my radar until maybe last year. And then even looking into it, the prosecutor who decided not to prosecute any of the officers that were involved has since retired, I believe in 2022. So you can't write a complaint to a Division of Criminal Justice about the prosecutor. The potential charges that these officers could face, they're all long past the statute of limitations for prosecuting these individuals. Things like assault or even manslaughter, some of those charges were way outside of the statute of limitations. So it's really just an unfortunate case in that I wish I would have been aware of it sooner when it happened, because there's so much that likely could have been done. But because it didn't come into my attention and my purview until a year ago, which was 6 years after Allen passed away, there wasn't a ton that we could do aside from petitioning and requesting that the video be released. And so I'm supportive of the video being released. I've relayed that to the governor's office. I've relayed that to the Attorney General's office. I've stated that in court, and I'm hoping that'll be the case, that the video does ultimately get released and we're able to have some transparency around the circumstances in which J. Allen was unfortunately killed.
So there is an interview, part of an interview there with DeVaughn Ward. And just to be clear, that the interview was undertaken before the latest court decision with regards to the video. Ali, you can give us an update on that now, because there has been some movement on it.
Right. So the judge ordered that the video be released with redactions regarding security measures in the facility, as well as to blur out J. Allen Jones's genitals. And this was happened when he was going in for a strip search. So since then, there's kind of been a bit of a stalemate. The attorneys for J. Allen Jones have filed objections and motions to reconsider and re-argue it because they're arguing that some of the redactions and the blurs made in the video prevent and obscure people from being able to see the hands of Department of Correction officers when they're punching J. Allen, as they claim, when they're pressing down on him, which ultimately led to his death.
Greg, any comments on that?
I think in some ways, what we're trying to do is we're trying to take this conversation out of the realm of just top public officials, top departmental officials, to actually give the public a role. And initially, the agreement or the offer from the Attorney General was a limited number of people could see this, a redacted version. So it was to keep the public out of the conversation. And I think what we've seen over the last, decade or so of sort of conversations about Black lives, about criminal justice, is that the public has an enormous interest in this, and the public wants to weigh in on this. But how can the public weigh in on this issue if they don't know what's happening? And you don't know what's happening unless you see the video. And we've heard that the video is horrific, I think is the sort of word. It's quite, and then the question is, what's obscene? Is it more obscene to see someone's genitals or to see someone die?
The other thing as well is ultimately when the final decisions are made about this particular case and the video, it will set a precedent for the future. And that's the important thing as well, isn't it? That, the courts in future who will have to deal with similar situations will then have something that they can turn to that will hopefully help, quicken maybe other cases that may be similar to this.
Every single time we intervene, whether with the Freedom of Information Commission or whether with a court, we know that we're trying to help and ease the way in the future for similar actions. And so, absolutely, this one, I think this is a meaningful case that will be cited for years to come.
We need to bring this segment, sadly, to a close, but just briefly, any final comments as to what happens now? Like we've said, there is still the matter is still in court. Ali, is there any final comments on this that you can give to us?
So it's still a question I think everyone asks is, well, when's this video coming out? And it's no one really knows. It's kind of a court battle. People are hoping after Thanksgiving, but considering objections and motions to re-argue, and there could be a potential appeal. I'm not sure, but could play out somehow. It's a question mark of when. We know if, but when.
Well, Ali and Greg, ever so many thanks for giving us an update on this case. And of course, we know that CT Examiner is continuing to follow this. So as and when we get some updates, we will bring them to our listeners here on the podcast. You're listening to CT Examiner Weekly as we discuss the criminal justice system here in Connecticut. Our next guest is no stranger to the prison system here in the state, having witnessed it firsthand when she served more than 6 years at the York Correctional Institution, Connecticut's only state women's prison based in Niantic, for non-violent crimes that remain on appeal. Chandra was the first inmate to write a regular newspaper column from behind bars, which was called Prison Diaries. Chandra, welcome to CT Examiner Weekly. I know we heard you a little bit earlier. You write a column for CT Examiner and recently touched on the topic of the legal program that's supposed to help inmates if they want to access the courts, but that's not always the case. Tell us more.
Well, the Inmate Legal Assistance Program, colloquially called ILAP, an abbreviation, is a service that is available to anyone who's incarcerated in the state system. They provide limited legal advice, legal forms, legal research for people who have usually civil claims or family issues that they are dealing with the courts, and they can't go to what's called a court service center, which is those open desks in the courthouses that help people who are representing themselves. That's what it does as a practical matter. But in the abstract, ILAP is how the state of Connecticut honors its constitutional burdens and its obligations to the incarcerated population in terms of getting them access to the courts, meaning are they allowed to petition the government for some type of redress, either with the problems that they're facing while they're incarcerated or even other issues. So this is, if ILAP isn't working, if ILAP isn't functioning as it's designed to, there might be considerably considering possibly a theoretical constitutional crisis at the Department of Corrections, because they are not giving inmates the supplies they need to access the courts.
You've done extensive research on this. There's a couple of articles actually up on CT Examiner, and obviously people can read those. But as we continue to have this conversation, now ILAP, as I understand it from your articles, is a 30-year-old system here in Connecticut. So it's been going for quite a while.
Yes, it's been around for 30 years, started in 1995 as a way to honor these laws that were created by the Supreme Court in two separate decisions regarding what exactly an incarcerated person needed in order to access the courts. And the initial answer was they need a full law library that has all the statutes and the forms and everything that anyone else would be able to access if they wanted to bring an action in their own name if they lived on the outside. Because law libraries are so expensive to start and even probably more expensive to maintain, there was another Supreme Court decision that said you don't have to do all of that. As long as you have somebody who can either give them the research, answer a few questions and a few forms, we're fine with that. And that's where ILAC came from.
I think, as I understand it, we have these rights, but sometimes to exercise them, we can't just do it on our own. In this case, if you're a prisoner, there's certain things that get in the way of you exercising what the courts say are your rights. So your ability to access a library, to have some kind of knowledge base, or to have access to legal representation. Is there what rights do prisoners have in the prisons?
So, well, a lot. First of all, but in terms of ILAP specifically, these rights stem from the First Amendment right to petition the government and the 14th Amendment right to due process and equal protection. So basically, the idea is that you cannot be blocked from asking the government to help you with another part of the government who may be violating your rights or harming you or not providing you with what you need. The other issue is many inmates who are incarcerated in Connecticut have family issues, family law issues, divorces, issues with childcare, custody, things like that. And very often people need to know what the law is so that they can either defend themselves so that their children aren't taken away from them, that their parental rights aren't eliminated. And I should say, as Connecticut courts got more and more advanced, the form that you need to start an action or to answer something is very important. You can't just put it on a piece of paper and say, this is what I want to say to the court. There are forms that are very specific. They have numbers, and they also have barcodes now that the court scans in. So if you don't have that form to say, I'm answering this, or I'm here to say I'm going to answer this lawsuit or whatever it is, then you can be defaulted, or it's like you don't even really exist, that you haven't answered, provided an answer or information to the court. So that's really important right now, because you can't get that form. I can get it online, but someone who's incarcerated can't. So ILAP, that's probably, I'm going to give a ballpark, that's probably a third of what they do is sending in forms to people who request them and say, this is my situation, what do I need to do? And they send the forms in.
Part of the problem, though, as I understand it from reading again your reports, is that a lot of this is done through the old-fashioned mail system and not electronically.
Correct.
And part of the issue for the inmates is that they get delayed mail.
Right. And
Talk to us about that.
Yeah, there was one gentleman who wanted to use, to be clear, we have the right to a public defender if you are the defendant in a criminal case, but sometimes people choose to represent themselves and forego that. And those people who represent themselves while they're incarcerated have a right to access the research and the forms that they need. And one gentleman wanted to use a particular case that he had read about in another case at his sentencing. And he wrote to ILAP and said, please send me a copy of this case. This is the date of my sentencing. I'll need it for then, send it on to me. And he went in, he had not received it before sentencing. He was sentenced to a certain period of time. And then the ILAP delivery came 2 days later. So it remains to be seen whether if he had that law in that case with him, that he would have received a shorter sentence or what would have happened. But the misstep of not being able to have that case when everyone else, in that courtroom could just pull it up on a computer or a phone, shows the disadvantage that an incarcerated person is at when they're in these courtroom proceedings. And that's basically what ILAP is supposed to do. They can't make it entirely fair for these people, but at least they're not going to be left out with not having cases and forms. If ILAP, I want to add, if ILAP is operating as it's supposed to.
And let's get to that particular point. There has been sort of allegations that it isn't doing exactly what it contractually should do. You wrote another article having interviews, and we heard from him earlier, DeVaughn Ward, the Corrections Ombudsman. Talk to us a little bit about that, because he wrote to the Commissioner of the Department of Corrections about ILAP. And when I did my interview with him as well, he said he wanted to see that system paused and reviewed because it's costing somewhere almost upwards of $1 million a year for the state. And DeVaughn Ward said he has questions about it.
Yeah, DeVaughn Ward has very good questions about it. Greg will remember, I actually started working on this about a year ago because I was hearing from mostly men who were getting out of custody who were saying, when did you leave prison, Chandra? When I said 2014, they said, oh, so you didn't have Walter C. Bansley IV. He's the head of the firm that runs ILAP. You didn't have Bansley as your ILAP attorney. And I said, no, when I was in, it was a gentleman named Sidney Schulman out of, I think, Hartford, outside Hartford area. And I said, why? What's going on? And they said, well, we think that Bansley got the bid over Schulman because he underbid him. And now there was some kind of secret promise that Bansley would not be too hard on the DOC if there were ever claims to be brought against the DOC by people who went to ILAP and said, I need help with this. This is what's going on. And indeed, that is what appears to be happening. There are several people who have complained to Ombudsman Ward saying that they actually believe that ILAP has thwarted their ability to raise claims against the state and the Department of Corrections. There are a number more people who are saying, I don't think it's great, but I don't think it's terrific. I don't really have much confidence that I'm going to get the forms or the research that I need in time. But there's very few people who are going to say that ILAP is doing a glowing job. I mean, even Bansley in finally answering through an objection, that court case that you had mentioned that DeVaughn Ward had filed against ILAP, he said, we're meeting all constitutional standards. He didn't say exceeding. He's not talking about doing an excellent job. Basically, he's saying we're doing the bare minimum that we are required, but he actually has no proof that that's happening. He's just making that assertion and leaving it there.
In terms of the bidding, I mean, I know there was some controversy. I'm a little careful about this. There's been no decision or no court has said that there was any wrongdoing.
No, exactly. And I should clarify that was the inmate rumor, right? So what the information that spreads around a correctional facility, we call it inmate.com. So these are rumors. And so the inmate.com rumor was that somehow Bansley had undercut Schulman. And the evidence of that was that Schulman had gone through a very lengthy Freedom of Information Act request appeal to get a copy of Bansley's bid for the program. And I think there's something that maybe has to be emphasized here, which is that this is a kind of a cash cow for a small firm to get the contract for ILAP. You're getting almost $1 million a year at a minimum. And it's not really clear that you do much more other than receive these letters of request for help, make some copies, and mail them back in. They're not required to take on any cases or represent anyone who asks for it. So it's a very lucrative contract.
Sorry, Greg, I'm just going to quickly add in, just to clarify, that DeVaughn Ward actually served 2 subpoenas on Bansley. Yes. I hadn't actually mentioned that, so I just wanted to back up on that in case listeners are like, okay, not quite sure what's going on there. He issued 2 subpoenas, which Bansley did not answer to, although I think on one he did actually ask for an extension, but ultimately did not provide the information that he was requested to do so. So just wanted to clear that up, Greg.
So I just want to, for my own sake, to understand, I think the sort of dysfunction of ILAP, I think you prove pretty clearly, and there's some basic data points about how many visits there were to prisons or other things that just show that there's something that isn't working right. So to be clear, this came up in a private conversation we had just a few minutes before we started recording, but the ILAP attorneys, they're contracted by the state, but they're not actually employees of the state. So there are different standards of what, like if I sent a Freedom of Information request to this law firm, they
have no obligation to answer it.
So no obligation. So it's a little bit hard to, do we know, are they obligated to provide, what metrics do they have to show their performance to the state?
They have to file a yearly report that says how many letters they've received, how many they answered, some of the nature of them. And then also there's a very specific data point, which they say actions initiated, meaning like how many actually resulted in someone filing a lawsuit. And from the numbers I saw, they were pretty low, like around 4 or 5, when you consider they're getting 1,200, maybe it's several thousand letters per year. And to be clear, that doesn't mean that everyone who's writing to ILAP has a colorable claim of whatever it is, abuse, violations of the 8th Amendment, problems with the conditions of their confinement. But it doesn't seem like ILAP is converting a lot of those requests for assistance into actionable results.
Greg, I'm going to have to bring it to a close, actually, because we're running out of time. But I just wanted to quickly mention to Chandra, because you and I both had a conversation before we started recording as well, and we have both received communications from DeVaughn Ward, which was an answer to a letter that he had sent to the Commissioner of the Department of Corrections back in October 9th, and has just received it on the 17th of November. 2 days later, he's now sent back a 4-page response to the Commissioner, basically not very happy about the information that's come from the Commissioner of the DOC. I'm not going to go into it because there's quite a lot there, but he's basically saying you've not answered the questions, and the Commissioner has to apparently either reject or accept what it is that the Ombudsman has put forward, which he has not. And apparently now this is being sent, copied into the governor as well. So this is a situation which we'll be coming back to you on, because obviously a very interesting situation there, and one that obviously is still yet to be resolved between the Department of Corrections and obviously the Ombudsman. Thanks ever so much for being with us. We're going to have to bring it to an end, unfortunately. That's the end of this edition. As I say, thank you to Greg, Ali and Chandra. Don't forget, you can read all the stories and our extensive coverage about the criminal justice system that you've heard about today. And don't forget to take a look at Robin's events calendar on the digital pages of ctexaminer.com. And don't forget to subscribe as well to make sure you don't miss out on all the week's news. This is CT Examiner Weekly, reporting and supporting what matters. I'm Brian Scott Smith. Thank you for listening.